study unit 4. Let me just get my settings right here. There we go. I think it's fine now. Right. The legal consequences once business rescue proceedings have commenced. What are the legal consequences? Now, the first one, and arguably the most important one, is the moratorium. In some jurisdictions, their rescue procedure is not really much more than just a moratorium, but for a very limited time. So not as in South Africa, where some business rescues go on for years and years with the moratorium in place. So Section 133 deals with a moratorium, and it states that no legal proceedings may be commenced or continued in any forum against the company or property of the company, property lawfully in its possession, but the practitioner may give written consent or the court may grant permission to a litigant to, in fact, start or continue legal proceedings. And then there are some exceptions which are quite obvious. Now, the words or phrases that I have highlighted, or rather put in bold, these are all part of this section or this provision that have really caused problems because they were unclear and we didn't really know what they meant. So, starting with the first one. The meaning of legal proceedings. The section doesn't say what it means by legal proceedings. So the first time it was tested was in the case mentioned in your notes, the LA Sport 4x4 case, where the High Court held that cancellation of a contract is also a legal proceeding. In other words, there's a moratorium on that as well. You cannot cancel a contract with a company in business rescue. This judgment was overturned by a full bench of the High Court. And in the meantime, the Supreme Court of Appeal had also issued its judgment in Murray versus First Rand Bank to say that cancellation of a contract is not a legal proceeding. It is a juristic act, but there is nothing to prevent a party to a contract with a company in business rescue to cancel the contract if there is a breach of the contract. So the contracts with companies in business rescue can be cancelled on legitimate grounds. The second question then was, what is the meaning of a forum when it says you cannot have legal proceedings in any forum? Clearly it meant a court, but what about arbitration or the labor court? Now, there is a case mentioned in your textbook where it was held that oh, goodness me, arbitration proceedings are also regarded as legal proceedings, which means that there is also a moratorium on arbitration. As far as labor disputes are concerned, you will see in your study notes there's a long discussion about several cases where the courts held that since the definition of a court in Chapter 6 of the Act does not include the labor court, it means the labor court has no jurisdiction to adjudicate any cases in during business rescue. Only the High Court can. That is still the case, except that we now have the NUMSA versus South African Airways case, where the Labour Appeal Court held that you can start proceedings in the Labour Court as long as it only concerns the matter of labor disputes. In other words, it's not about money, it's not a claim, it's just about retrenchments and specifically the protection of employees during retrenchment, because the Labour Appeal Court also confirmed the Labour Court has a duty under the Labour Relations Act to protect employees in cases of retrenchment. So apparently the Labour Court has just created an exception for itself, although there is no basis for it in the Act. Then The third problem is the moratorium talks about, let me just go back to that slide so you can see. It says enforcement proceedings in forum against the company, that's clear enough, property lawfully in its possession. Now, the original interpretation was that all these inclusions are really just an effort to make this moratorium as wide as possible. In other words, any legal proceedings, whether it's against the company or its property or property in its possession, whatever, it's subject to the moratorium. And you will see that we had some cases early on saying that if a company is in unlawful possession of another person's property, then the moratorium doesn't apply. Now, on page 304 of your textbook, the last part of that paragraph, starting with this provisionally initially caused substantial uncertainty, you have to delete that part which says this is not correct since the moratorium applies to all legal proceedings against the company. That is so in other jurisdictions, but the Supreme Court of Appeal had a different interpretation, and that's the case where that's mentioned here on the PowerPoint slide. Timasami Sani versus Afrimat Iron Ore, where the court said, no, this is not just one moratorium. It's actually 3 moratoriums or 3 situations. So in other words, it's personal actions against the company. There's a moratorium. There's also a moratorium in relation to any property belonging to the company. And then thirdly, properly lawfully in its possession. However, if the property is no longer in the lawful possession of the company, for instance, as you will see in the examples in the textbook, where a contract with the company has been cancelled, which we now know can be done. If the other party to the contract cancels the contract so that the company is no longer in lawful possession of that other party's property, for instance, a lease contract, a rental contract is cancelled because there was a breach of contract, then the company is no longer in lawful possession of that property, and then the moratorium doesn't apply. So in that case, then the other party who has cancelled this contract, if that party wants to claim that property, ask or apply for the eviction of the company from rental property, subject to the moratorium because the company is not in lawful possession of that property. Then the next question then was, the moratorium can be lifted with the permission of the court or leave of the court. The question then was, must you apply for leave of the court before you institute the legal proceedings, or can you combine the 2 processes? In other words, your first plea is then for permission of the court, leave of the court to institute or continue legal proceedings, and then the second one would then be your plea or your prayer for the main relief that you are seeking. Now, nobody really gave it much thought. It was just assumed that you could do this together, and that's what happened in most cases. But then came the case of Elias Mechanikos, which is mentioned in your textbook. It's actually, the name is in a footnote 107, I think, but it's at the top of page 305, where the court said, no, you can't do the 2 together. You first have to apply to court for leave to institute or continue legal proceedings. And once, if you get that consent or leave, then you can institute the legal proceedings or continue. You cannot combine the 2. There were other cases where the courts disagreed and said it's unnecessary costs. Some which said, well, if you're already before the court, then there's no need to ask for permission again to continue. And then a case such as Boysen versus Jonker, where the court said, well, it will depend on the circumstances. So they didn't want to take a firm stand, but they said it will depend on the circumstances. In some cases, you won't need to ask permission. And in some cases, you have to do it separately. But they were not very clear about under what circumstances it has to be a separate application. At least in Boysen versus Jonker, the court mentioned the fact that you have a constitutional right to approach the court, and you mustn't easily limit that right. In BP Southern Africa, which is mentioned in your textbook, it said that a court cannot decide whether to grant leave to institute or proceed legal proceedings unless the court knows what the prospects of this application is, if it has any grounds. So if you have to apply separately and your main application is not before the court, how will the court be able to decide whether to grant the leave or not? So in this case, which I think is really the sensible one, the court said, no, you can do the two together. So you apply for leave, and at the same time, you also institute the legal proceedings, subject, of course, to the condition that the court grants leave. And then the court will be able to decide whether this is a case where the moratorium should be lifted or not. So far, we haven't had a Supreme Court of Appeal decision on that, so that is still quite uncertain. It could go either way, whether you have to apply in a separate application or whether you can combine the two. You can argue for separate application if you want to say that you don't want the company to spend money on opposing legal proceedings, because maybe the court will say, well, they're not going to lift the moratorium, and then that money has been wasted. But I think you have to disclose if you oppose the application for the moratorium to be lifted as a company in business rescue, you will have to basically say what your defense is or what your reason is, and I think that will already be really part of your main defense against this application. So I think the sensible thing is really for the two to be confined, but unfortunately it differs from one court to the other. So you're never quite sure what line the court is going to take, whether it will require a separate application for leave to lift the moratorium or whether it will accept a combined application. Okay, then we go to the protection of company assets. That basically says that the company property cannot be sold unless in the ordinary course of business, or if it's approved in writing by the practitioner or as part of the business rescue plan. Quite importantly, Section 134(3) states very clearly that secured creditors, pre-commencement secured creditors, are protected in that the sale of an encumbered asset by the company can only take place if the proceeds of the sale will be enough to pay the secured creditor in full, or the secured creditor has agreed to the sale of this property. That's quite important to keep in mind, because you will see that there are some judges, even judgments, where the court seems to imply that secured creditors, pre-commencement creditors, are not as protected as secured post-commencement creditors, which is nonsense, because there are Supreme Court of Appeal cases, the Diener case in particular, which we'll get to later on, where the Supreme Court of Appeal made it very clear that you cannot dilute the rights of pre-commencement secured creditors without their consent. That is an absolute fact. Okay, then here we have again the property of another person in lawful possession of the company. Again, if it becomes unlawful, then it's no longer protected. and also property of the company in the lawful possession of another person, subject to section 136, which is the right of the practitioner to suspend or the court to cancel a contractual obligation, in which case the other party would probably then have to return the property of the company. Okay. There is a reference to the position of a surety on page 305 of your textbook in Investec Bank versus Brains. This was where a surety was called upon to pay a debt of a company for which this surety had given the suretyship. And this person, the surety, tried to use the moratorium as a defense. And the court said, no, the moratorium is a personal defense. Defense in personam. In other words, only the company has this benefit. It is not for everybody. It's not a defense in rem, so it applies only to the company. Only the company can use this defense. You'll see later on when we talk about the consequences of an approved business rescue plan that the matter of suretyship payments or liability, etc., after commencement and after approval of the plan has also now, after many problems, been settled by the Supreme Court of Appeal, but we'll get to that later on. Okay, then okay, the National Union of Metalworkers versus Laser Services, where the practitioners instructed auctioneers to sell assets, and then the trade union opposed that because they said that they are entitled to the proceeds first, and then the court said no. This is a secured asset. The secured creditor, post pre-commencement secured creditor, is entitled to the proceeds of this secured asset, and the court actually called the business rescue practitioners reckless for promising employees that they could be paid from the proceeds of a secured asset. Right, then post-commencement finance. Now, this is also a very important aspect of business rescue because a company in business rescue obviously doesn't have money and it needs working capital to continue with its rescue. So you see there the example, South African Airways and South African Express, SA Express. South African Airways was only could go through business rescue because of the money that the government provided. SA Express did not get any money and they were eventually liquidated. So they couldn't be rescued because they just didn't get finance. So there are several cases in which the court refused the business rescue order because the company could not show that it would be able to get post-commencement financing. So because it is so important, there's a section 135 which is specifically dedicated to post-commencement finance and the ranking of claims. Now, you would expect such an important section to be very clear, but unfortunately, once again, very poorly drafted and very confusing because you would have expected the section to set out the order in which the various claims enjoy preference in that order, but they haven't. They start off with a preference 2, then number 3, then they go back to number 1, and then the last one. So it's very confusing and really not very well drafted. So to give you an indication of what the correct ranking of post-commencement claims is. And it's important to get this right because this ranking continues to exist even if the business rescue fails and the company goes into liquidation. So it's very important to have this in the right order. Let me see. Okay, yeah. First in line is the business rescue practitioner's remuneration, expenses, and other claims arising out of the costs of business rescue proceedings. Now, the Act is not clear at all what it means by costs, claims arising out of the costs. And some commentators believe that this would be all the costs of running the business rescue proceedings. So in the case of SAPOA versus the Minister of Trade and Industry, it's mentioned in your textbook, and I think also in your study notes. The South African Property Owners Association claimed that they were entitled to be paid rent, or at least the rates and taxes that they paid on a property that was rented by the company in business rescue after commencement of business rescue, or that continued to rent this property. And they said that these would be costs of business rescue proceedings. And in this case, it was important because the only asset there was secured property. And so they wanted to be paid, or their claims for post-commencement rental and rates and taxes, etc., to be regarded as costs, because then it would be first in line in the ranking. In a subsequent liquidation, the court said, no, the costs that are referred to here are the costs, the personal costs, really, so to speak, of the business rescue practitioner. In other words, the costs that a business rescue practitioner has to incur to pay or to continue with basically to exercise his functions. It's not all costs, and payment of rental is most certainly not part of those costs. Now, there is a proposed amendment of Section 135 to cater for this situation. Clearly, SAPOA has friends in the right places, in high places, because this proposed amendment will actually give landlords a preference right to rates and taxes that they have paid on a property that is rented by the company in business rescue, where this company in business rescue is not paying rent. So in other words, they will be ranked more or less equally with the claim of the business rescue practitioner, and they will rank before all these other preference claims. Nobody else is going to be given that special right, not post-commencement, people who deliver supplies after commencement, or people who provide services and have not been paid. They don't get the special treatment, only property owners, which seems rather unfair if you consider that the property owners are able to cancel the rental contract and take back their property, and then they have the property again, they can rent it out to somebody else. People who provide services and goods, they can't get it back. Once it's been given or provided to the company, it's lost, and they have no security for their claims, and they will rank with concurrent creditors right at the back, right at the end of the queue, if there is a free residue available in the case of a subsequent liquidation. So the second ranking is then what is referred to in the Act as post-commencement financing of employees. And that means any claim of an employee for salary or bonus or commission or leave credit, whatever claim, there's no limit on this claim. All claims are treated equally, and they have preference over all claims for other post-commencement financing. In other words, where a bank, for instance, provides capital to the company to continue the business rescue, this claim of the bank will rank after the claim of employees. Now, why they thought it would be necessary to call this claim of employees post-commencement financing, I don't know, because post-commencement financing all over the world has just one meaning, which is people who provide money, capital, to the company so that it can continue its business during the rescue procedure. The employees are not providing money to the company. It's just that they have a claim against the company. So, and it's not willing because they would rather be paid. I don't really see the reason why it had to be called post-commencement financing, because it doesn't matter what you call it. You don't have to call it anything. You can just say that the employees have a preference claim. The problem now is, of course, in a subsequent liquidation, the Insolvency Act applies, and it limits the claims of employees. So what we've now seen is that employees actually have two claims in the case of liquidation. They have the claim that is allowed under the Insolvency Act, and which is very strictly limited. I think it's a 3-month salary. And then there's also an amount, there's a limit to the amount. Plus, then they have this unlimited claim for their post-commencement claims, any amount that was payable to them, and that must be paid first out of the free residue, together with any unpaid fees or costs or remuneration of the business rescue practitioner. And research by the University of Pretoria has shown that as much as, I think, almost 40% of the free residue in companies that go into liquidation after business rescue, almost, I think it's 37% or something like that, has to be paid from the free residue to for these two claims first, before the free residue can be used for any other concurrent creditors. Then third in line, the claims for what I would call real post-commencement financing, and it doesn't even matter whether this is secured or unsecured, it still ranks after the first two. And also, the Act says that the preference is in the order in which they were incurred. So, in other words, if a secured claim was secured, a real post-commencement claim was secured after an unsecured financing was given, then the secured claim will rank after the unsecured claim, which really doesn't make sense, because it could be shareholders who provided unsecured post-commencement financing. Then the bank comes in and somehow manages to get some security for its claim, but now it still ranks after the unsecured claim for post-commencement financing, which really doesn't make sense. I cannot see a bank going for that. Then this claim will then enjoy preference over all unsecured claims, post and pre-commencement. The question then is, are all post-commencement debts, for instance, for supplies and services delivered post-commencement, regarded as post-commencement financing? And there are commentators who actually argue that all of these are also should also be regarded as post-commencement financing. But then there would be no unsecured post-commencement claims left, because they would all be post-commencement financing, which would put them one step higher up. The last in line then would be all unsecured claims, post and pre-commencement, which of course in a liquidation means that they will get even less than usual, and most often absolutely nothing. So section 135, which is supposed to make it better or easier to get post-commencement financing, has really just added to the very the difficulties for a company in obtaining post-commencement financing. Then we have employment contracts and employees. You can see that right through Chapter 6 that there was a very definite intention to protect employees and employment contracts at all costs. So the employees remain employed on existing terms and conditions. You cannot reduce their payments unless they agree. They become preferred unsecured creditors in respect of unpaid remuneration that was due before business rescue commenced. Employees also have the right to attend a meeting within 10 days after the appointment of the practitioner. They may form an employees committee. They must be represented by their registered trade union if a member, and as affected persons, they may apply for business rescue. Now, you will see eventually that employees enjoy far more rights in business rescue than shareholders, for example. Now, I mentioned, let me see. The Diener case, let me just see where we discussed that. I know it's in your study notes. I'm just not sure. I think we discussed that when we get to the fees of the business rescue practitioner. So we'll talk about it at that point. Employees, then, I think we've dealt with in enough detail. That's not too complicated. Uncompleted contracts, you now already know that a company or an outside party may cancel a contract with a company in business rescue if there is breach of contract. However, apart from that, to protect the company in business rescue, the practitioner is given the right to suspend pre-commencement contractual obligations. So obligations that have to be performed during business rescue, but that originate from a contract that was entered into before business rescue, can be suspended by the practitioner, except employment contracts and financial markets contracts, which means, strictly speaking, that if the practitioner suspends an obligation before the company has defaulted on its performance, then it will not be a breach of contract because the practitioner is exercising a statutory right to suspend the pre-commencement obligations. The practitioner may also apply to court to cancel a contractual obligation on terms that are just and reasonable. I've never seen this happen, so we don't really know what the courts will regard as just and reasonable, but you can apply to court to cancel where there's a very onerous obligation on the company that will really make a rescue impossible. And the other party to the contract may claim damages only, but not specific performance. Now that all sounds very good. So in other words, if the company is not already in breach, so that the other party has the right to cancel the contract, then the practitioner can suspend this obligation, and that is not a breach of contract. However, you will see that in BP Southern Africa versus Intertrans on page 310 of your textbook, the court held that where a contract contains reciprocal obligations, in other words, I have to perform a certain obligation, and then in turn the other party to the contract has to perform some obligation. In the case of reciprocal obligations, our common law provides that if I don't perform my obligation, then you don't have to perform your reciprocal obligation either. So if I am a company in business rescue and I suspend my obligation to you, although that is perfectly legal because the Act says I may do that, that would still be grounds for the other party to say, well, it's a reciprocal obligation. You have not performed your part, so I'm not going to perform my part. So if you don't pay rent because you've suspended payment of the rent, then I don't have to make my property available to you. And on that basis, I can cancel the contract and get an eviction order from you. So in that respect, this right to suspend the contractual obligation is not worth much. We don't have a Supreme Court of Appeal decision on this yet, so we don't know if the Supreme Court of Appeal will agree with this, with the application of this principle of a reciprocal obligation. But as things stand at the moment, even though suspension of a contractual obligation is not breach of contract, it can still lead to the termination of the contract, and then the company in business rescue will not really get any benefit from that. Shareholders, they don't play a very big part in business rescue, although they are the ones who will lose everything if the business rescue doesn't work out. But they only have rights to vote on the rescue plan, for instance, if their rights will be affected, directly affected. Otherwise, their rights may not be changed, so the rights attached to their shares. So their participation rights are very limited. They don't have the right, like employees, to have a meeting with a business rescue practitioner. They don't have the right to form a committee of shareholders to look after their interests. So in all, the shareholders are really the orphans of this whole procedure. Directors continue to hold office and must perform their functions, but under the authority and instructions of the business rescue practitioners. They must also cooperate with the business rescue practitioner, but they are excused from most of their fiduciary duties and duty of care and skill in terms of section 76 and 77, as long as they act under on the instructions of the practitioner. They may be removed from office if they fail to cooperate with or hinder the business rescue practitioner, but that can only be done by an application to court. So, no, most business rescue practitioners will not want to waste time and money on going to court to have directors removed from office. Let me just see, there was... Oh, yes. We'll get to that when we talk about the rights and duties of the business rescue practitioner, about what rights the directors still have in the company. Creditors are very important because they have, like all affected persons, they have the right to be notified of and to participate in all stages of the proceedings, but they have the right to form a creditors committee to represent their interests and to consult with the business rescue practitioner. And each creditor has a voting interest equal to the value of that creditor's claim against the company, irrespective of whether it's secured or unsecured. Now, those of you who are familiar with insolvency law will know that a secured creditor does not have a vote, except for the part of his claim that is unsecured. You don't have a vote for a secured claim, based on a secured claim. For some reason, the drafters of the Act decided that as a secured creditor, you have a vote for the full amount of your claim, even the secured part, which means that you can vote on the plan, even though, as I've already pointed out, as a secured pre-commencement creditor, your rights may not be diluted. Then independent creditors, you'll see there's a definition for independent creditors in section 128, because sometimes you only need the vote of independent creditors for certain resolutions or certain decisions. Subordinated creditors, these are creditors who will only get paid after the ordinary creditors have been paid in full or a certain amount or whatever. In South African Revenue Services versus Beginsel, the court made it very clear that in our law, no creditor is subordinated by law. The only way a creditor can become subordinated is by agreement, in other words, by contract. So if a creditor has not contractually agreed to be subordinated, then that creditor will not be subordinated. And that's important because a subordinated creditor only has a vote based on the value of the claim or the payment that he or she would probably receive in a liquidation, which in most cases would be zero. So it's very important that people should realize that not every concurrent creditor is a subordinated creditor, which is what in this case they try to argue. Right, and a creditors meeting must also be held within 10 days after appointment of the practitioner. Now, study unit 5, the business rescue practitioner, the main man or woman in the business rescue proceedings. Appointment, you already know now that in the case of a commencement by board resolution, the board appoints the business rescue practitioner, but the board cannot remove a business rescue practitioner. You always need an order of court. Again, the effect of Panama Properties versus Nel, even if the business rescue practitioner is not appointed within 5 business days, that will not lead to the end of the business rescue. I recently heard of a case where no business rescue practitioner was appointed for 18 months after commencement of business rescue, but because of Panama versus Nel, the business rescue did not terminate.